table. Honourable Senators, we are meeting today to continue our study of Bill S-250, an act to amend the Criminal Code sterilization procedures. Before we begin, I'd like to inform members that after holding 3 meetings in relation to this bill, Senator Boyer, the bill's sponsor, has shared a substantial draft amendment with all members of the committee. She did that last spring, and she intends to move that amendment during clause-by-clause consideration. Given the substantial nature of that amendment and this development, steering members felt that it would be beneficial for the committee to hear from departmental officials regarding the amendment to the bill, which would bring us as up to date with respect to consideration of S-250 as possible. So this will provide us with a clearer understanding of its implications before we proceed to clause-by-clause consideration or decide on any other alternative course of action. As such, I'm pleased on your behalf to welcome officials from the Department of Justice, Justice Canada, Natalie Levman, Senior Counsel, Criminal Law Policy, and Morna Boyle, Counsel, Criminal Law Policy Section. Once again, thank you for joining us. We're going to begin, it's a bit unusual with respect to Justice Canada officials. Normally we just pound away our questions at you, but in light of the circumstances, I'm going to invite you on our behalf to provide some opening remarks before we move to questions for up to 5 minutes time, and then a conversation with our senators. Thank you. Ms. Levin.
Thank you very much for the opportunity to speak to the sponsor's proposed amendment to Bill S-250 that I understand from your remarks you're considering now. My colleague and I will attempt to explain the impact of that amendment and answer any questions you may have. So the proposed amendment would first clarify that coerced sterilization is a form of aggravated assault, and also expand the bill's definition of sterilization procedure to include all sterilization procedures, regardless of whether sterilization is the procedure's primary purpose and regardless of whether the procedure may be reversible through a subsequent surgical intervention. In particular, the amendment would clarify that the law of assault continues to apply to all coerced sterilization procedures, just as it applies to all coerced medical procedures. It would do this by specifying that a sterilization procedure constitutes a wounding or a maiming for the purposes of the aggravated assault offense in Section 268. This is, as you all know, the Criminal Code's most serious assault offense, carrying a maximum penalty of 14 years imprisonment. It applies where an assault wounds, maims, disfigures, or endangers the life of the victim. Because surgeries necessarily involve wounding the patient, they constitute aggravated assault if they're performed without the patient's consent. Now, the Supreme Court of Canada has clarified that the law of assault applies to any medical procedure carried out on a person without that person's consent. That's from Morgentaler, 1988. The court has also clarified that assault law will recognize consent to applications of force that have social value, such as appropriate surgical interventions. And that is from Jobidon, 1991. Now, both jurisprudence and the Criminal Code articulate the law of assault, including the meaning of consent in that context. Assault was originally an offense at common law, but is now defined in subsection 265(1). Assault law applies where a person applies force to the body of another person, knowing that the person does not consent to that application of force, or being reckless as to whether that person consents. That's articulated also in the Supreme Court of Canada's Williams case, 2003. Because the act of applying force means to bring something into contact with the body, a non-consensual medical procedure constitutes an assault. However, if a person who undergoes a medical procedure provides legally effective consent to that procedure, the procedure will not constitute an assault. So what does legally effective consent mean? Well, it means that consent must, first, be freely given, second, go to the nature of the act, and third, be given with the ability to understand. These rules were developed at common law, but some are also reflected now in subsection 265(3) of the Criminal Code. That provision non-exhaustively lists circumstances in which consent to the application of force is not legally valid. Notably, these rules are consistent with concepts of voluntariness, knowledge, and capacity in provincial and territorial health law, such that compliance with the health law requirements regarding consent protects fully from criminal liability. Freely given consent means the absence of fraud or duress. This rule is codified in subsection 265(3), which specifies that consent is not obtained in law where the complainant submits or does not resist by reason of violence, threats of violence, fraud, or the exercise of authority. So this rule is at issue where a patient is pressured or deceived into consenting to a medical procedure. Consent to the nature of the act requires a foundation of knowledge, which has been described as knowledge of the purpose of the operation, knowledge of the events, and perception as to what is about to take place as to the character of what is done. This rule is at issue where the patient is not provided with sufficient information to understand the nature of the procedure to which they are consenting. Ability to understand means that patients must be able to appreciate the nature of the act. This rule is at issue where the patient is a child or has a cognitive impairment. That concludes our opening remarks, and we welcome any questions you may have. Thank you.
Thank you, Ms. Leveman. That was very helpful. I appreciate it. We have now questions from senators, beginning with Senator Batters.
Actually, I'm wondering if perhaps, given that, this amendment, if perhaps Senator Boyer wishes to maybe, would that be okay? If Senator Boyer has anything to add to that first, perhaps?
I think that would be an excellent suggestion. Senator Boyer?
I do have some areas that I can add to that, and then I do have a question. So just for a bit of an explanation, at our last committee meetings in the spring session, it was clear to me that both senators and witnesses had concerns about the broad drafting of Bill S-250 and the potential for unintended consequences, especially in cases of emergency surgeries or medical procedures resulting in sterilization. And after consulting with the Minister of Justice and his advisors, we developed this amendment that significantly simplifies the bill while maintaining the core goal to make it explicitly clear that in the criminal code, forced sterilization is against the law. Clause 1 of S-250 is amended on page 1 lines 11 to 22 with a for greater certainty clause, which clearly brings sterilization into the aggravated assault provisions in section 268. It's placed after the female genital mutilation section. The original 250 has been reduced from 55 lines down to 14 lines. This amendment ensures that medical providers who sterilize someone during an emergency surgery are indeed protected by Section 45, and it clearly targets coerced sterilization, so it will not impact reproductive freedoms for those who wish to be sterilized voluntarily. The reason why this bill is before you has been talked about many times over the past 6 years. The issues are not going away. I spoke in detail as a witness before you. We brought in survivor Nicole Rabbit. We brought in other witnesses who've all agreed something has to be done because these women are still being sterilized. And that was the birth of S-250. We studied it at the Standing Committee on Human Rights and produced 2 in-depth reports on it. We studied it in this committee over 2 days. We heard from 16 witnesses, including the Criminal Law Policy Director, Council, and Department of Justice, and the Executive Director and General Counsel of the Women's Legal Education and Action Fund. We heard from Elisa Lombard, who's leading one of the 5 class actions in Canada. She holds a Master's of Law and is a skilled courtroom litigator. We heard from medical experts. We heard from the Indigenous midwives. Yesterday, the Canadian Medical Association apologized for forcing and coercing sterilized women in this country. We heard from Native Women's Association and the Government of Canada and the survivor, Nicole. This bill targets specifically the act of coerced sterilization in the aggravated assault provisions of the Criminal Code because we have simplified S-250, but it will have an intended deterrence effect. I listened to what the witnesses said. I listened to what my honorable colleagues have said. I listened to what the Minister of Justice and Attorney General said, and I agreed. This simplified version removes any unintended consequences while still sending the clear message that forcibly sterilizing someone in Canada is illegal and will not be accepted. So the question I have for you is, we know that the goal of S-250 has always been to stop people in Canada from being sterilized against their will. Do you think that my proposed amendment will help accomplish that goal? And do you have any concerns about the new approach that's being proposed in this bill?
Thank you. Yes, we did have occasion to think about what the impact of your proposed amendment would be. And I would like to underscore that the proposed amendment in no way alters existing assault law. However, it does underscore that the law of assault continues to apply to all sterilization procedures, all of them, that are performed without the patient's legally effective consent. Many witnesses who have, I believe, come before you have noted the potential deterrent effect and raising awareness impact that the criminal law may have. But also, your amendment underscores that valid consent must be provided to all sterilization procedures, regardless of whether sterilization was the primary purpose, regardless of whether subsequent surgical intervention could reverse it. So there is clarity there through the amendment that you've proposed. And as you've already noted, of course, it would also ensure that Section 45 is available to medical practitioners who are in the course of saving someone's life who can't consent, for example, because they're unconscious. You've also addressed the chilling effect concern that was expressed before you while you were studying this issue before summer recess. And because your amendment will not in any way change the scope of assault law, it can no longer have that effect. I hope that helps, Senator.
It does. I just have one more thing, Chair, if I may. Shortly before our meeting today, I was made aware of a concern that the Justice Department officials shared in relation to being coerced included before sterilization in the amendment. So, as you explained, clarifying that a sterilization procedure is an act that wounds or maims for the purpose of the aggravated assault provision would underscore that the law of assault, including its consent rules, apply to sterilization procedures. So you're saying that we really should take that word coerced out of the existing motion that we have before us today. Is that correct?
I'm saying yes, that including the term coerced could be interpreted as requiring proof of something more than absence of legally effective consent under assault law. And that could make non-consensual sterilization procedures more difficult to prove than other forms of aggravated assault, which I understand is not at all the committee's intention or objective. And that is why the concern was raised. It would also, the approach is also ensures that your amendment's consistent with the approach of related provisions, in particular the female genital mutilation provision, which you've already noted in subsections 268.3 and 4. And these clarify that excising, infibulating, or mutilating female genitalia is a wounding and a maiming for the purposes of the aggravated assault offense. And they also clearly specify that any consent to that conduct is not valid in law unless it falls within some narrow legislated exceptions, and those exceptions are for legitimate medical procedures, such as removing a cancerous growth or repairing the damage caused by FGM. So only within those parameters, the parameters of those exceptions, will assault law's consent rules operate. In any other situation, the code specifies that consent to FGM is not valid in law. That's because FGM is not a legitimate medical procedure. It has no social value, to use the Supreme Court of Canada's language from its Jobidon decision. And that contrasts significantly with sterilization procedures, which of course are legitimate medical procedures that do have social value, provided that legally effective consent is provided. So that's why the assault provisions are silent on consent in respect of legitimate medical procedures. This means that assault law the assault law consent rules always apply to legitimate medical procedures, and that those procedures constitute assault where those rules are violated. So perhaps it helps to think of it this way. What makes sterilization procedures coerced is the failure to follow the assault law consent rules.
Thank you. I agree that coerce should be removed from the motion in front of us today.
So could we anticipate, just for those of you who have not seen this, I've seen the version that I think Senator Boyer will present. It will have the word coerced removed. Perhaps others have already seen that, but that's just a tiny little tweak on what we have been working toward in the last couple of days. So I want to first thank Senator Boyer and thank Senator Batters for providing that opportunity for a little bit more complete explanation of where Senator Boyer is proposing to take this. But now for questions, Senator Batters.
Thank you. Yes, thank you both to the justice lawyers for being here and to Senator Boyer for providing that information, because that was very helpful to kind of start this today. So one thing I'm just wondering about, so is it correct that the Department of Justice lawyers assisted Senator Boyer with these amendments? Is that correct?
Would Senator Boyer like to answer that question?
Well, I'm wondering from the Department of Justice what, perhaps it wasn't the two of you, but other people in the other lawyers in the Department of Justice?
This is my area of expertise.
Okay.
And Morna also. So any work done on this file would have been done by us.
Okay.
Yes.
So did you assist with the amendments or no?
Yes, the senator has just confirmed, yes.
I'm sorry?
Yes, the senator has, Senator Boyer has just confirmed that, yes.
Okay. All right. And was that by reviewing the amendments that Senator Boyer prepared and providing your opinion, or was that by actually providing assistance in drafting the amendments?
We assisted through our minister's office. So that's how it would have worked. We were consulted, and Justice legislative drafters were involved.
Okay. So the minister's office asked you to provide that assistance? Is that
correct?
Okay. And is that an unusual situation, like that you would provide either a senator or, who isn't a member of the government with, government sponsoring government legislation, or an MP who perhaps has a private member's bill? This is kind of the equivalent of an MP's private member's bill. Is that an unusual procedure to help a senator or an MP who's not the government sponsoring person with that type of assistance?
Well, we're only permitted to do it if our client asks us to do it.
Minister asks?
Yes.
Okay. In your experience, because I know you've been with the Justice Department for a very long time and you've done excellent work, Ms. Levlin, Ms. Levin, but I'm just wondering is that unusual in your experience?
It is unusual.
Okay, thank you. And I note, Ms. Levin, that you said in your in response to a question that Senator Boyer asked, you clarified that in no way, quote, in no way does this alter existing assault law. But then you provided the proviso that this does provide some clarity on this matter. And that was an issue that I had raised with the previous justice lawyers that had come before the committee, some of your colleagues. And I brought up the number of different types of offenses that this could already fit within under the criminal code. So I agree that then this is a good idea to provide clarity. But yes, I just wanted to just clarify that this offense could well already fall within the existing assault law, as you're nodding your head in agreement on that. Yes, all right. And I do agree about the need to take out the word coerced out of the, what is 268.1 sub 1 in this proposed amendment, because to say coerced sterilization procedure, I think could also add another element that the prosecutor would have to prove in that case to say coerced. And then in sub 2, the definition provided for sterilization procedure simply says sterilization procedure and then provides the definition rather than coerced sterilization procedure. So is that also part of your reasoning that you think it's problematic to include the word coerced?
I think the main concern about including the term coerced is that it looks like it adds another element to the offense that needs to be proved by the prosecutor. So not only would the prosecutor have to prove violation of the assault law consent rules, but also that the sterilization procedure was coerced in order for it to fall within the amendment if coerced were retained in the amendment. And my understanding is that that is not the purpose. The purpose of a for greater certainty clause, and you've pointed out that it is a for greater certainty clause, is to clarify the law, not to change it. Just like the female genital mutilation provisions that are in subsection 3 and 4 of section 268.
Yes, and just for those watching who may have been following this bill, what this proposed amendment that Senator Boyer is going to bring to her bill, what it really does when you look at, it's not that long of a bill to begin with, it's like about 2.5 pages, but what it actually does is it changes the wording on the bottom half of page 1, which is the operative section, and then it deletes the entirety of page 2 and deletes the entirety of page 3. So it's really a very substantial paring down of what is actually going to be included in this bill, and I just wanted to include that visually so that people realize what we're dealing with here. But thank you very much.
Thank you. Senator Dalphond, you had been fully engaged in the conversations about the original drafting of the bill, and it's now your turn to ask questions with respect to the contemplated amended version.
Thank you, Mr. Chair, and welcome back. I won't have much questions, maybe one for the officials, but before that, I would like to say that I thank Senator Boyer for having listened to the concerns that were raised on the table. I voiced some of them. I think I even wrote a note to you, and I appreciate the understanding and the willingness to. We share the same objective, and we want to make sure that it is as clear as possible. And I think this is a very good thing. My second point is really about the participation of the Justice Department. So maybe just to clarify for those that are listening to this meeting, I understand it is, and correct me if it is not, that now Justice Department will attend the clause by clause for private bills from MPs as well as from senators.
Thank you for the question. Yes, we usually do. We usually are invited to attend clause-by-clause review of bills, whether they're government bills or private members' bills, which of course includes Senate public bills.
And I think also you were there, but I thought maybe not. But I think the minister was sitting at the table, and he was asked, maybe it's another bill, but he was asked if you will provide assistance, and he said yes. So that then came the instructions to assist. But certainly, I appreciate the fact that you assisted. It's an important bill, and let's do it straightly and rightly. And I'm told that, I don't know if you know that, but in 2017, the Justice Department assisted former Senator Bob Runcinan, a past chair of this committee, with a bill to facilitate voting on the Canada-U.S. Bill S-233. So I guess this is not the first time that you do it. It's not the first. It's a rare occasion, but it's not a first time. Am I correct?
Unfortunately, I don't have the big overview of every justice official and how they interact. I know in my personal experience it's happened rarely, and that's why I answered Senator Batter's question as it's unusual. But you may have more experience in this regard than I do. So thank you for informing me of that.
We'll call Senator Delfond as a witness on another occasion, I'm sure. Thank you, Senator Delfond. Senator Prosper.
I don't have any questions. Yeah.
Senator Simons.
Thank you very much. I'm looking at, because I do not have the criminal code by heart, I'm looking at section 265. And under consent, as you mentioned, it enumerates the exercise of authority if the complainant submits or does not resist by reason of the exercise of authority. So would you interpret that to include a doctor who is perhaps in a position of class authority? I mean, a doctor is an authority figure, but not like a police officer or an employer. But would a doctor, in your interpretation, still be a person exercising authority?
That's a really excellent question. First, I'd like to start by saying we don't actually have case law on that point. So I want to caveat what I'm saying with that. What we do have are a number of Law Reform Commission papers from the early 1980s that deal with assault, medical treatment in the law, and even one on sterilization. Now, they're fairly dated, but assault law is very ancient.
We've been assaulting each other since Cain and Abel.
Unfortunately, yes. So it's very ancient law. It was developed at common law, and so much of what those reports say is still valid today, with the exception of Joe Bidon, those cases that I mentioned that were of course decided afterwards. And one of the things that those reports note is that there's nothing inherently authoritarian about the relationship between a doctor and a patient. So absent something more, despite the fact that there is an obvious power imbalance if you're unwell and you're going to a doctor for help, they're not in a position of authority, says that Law Reform Commission report, in the same way that, let's say, some of the other officials you noted may be. But what I would point out is that what's really operative here is fraud in particular, in the case of coerced sterilization. So cases that involve, and I know you've studied these cases at length, and that there are a number of parliamentary reports that go over the different types of cases that have come to the fore, let's say, and we've recognized that there are people who are lied to about the nature of the operation, whether or not it's permanent, it's easily reversible, or it doesn't impact reproduction at all, which of course neither of which is true. So that is more of an operative provision in the case of coerced sterilization procedures, and also of course duress as well, the principle of duress, of pressure. if somebody is told, for example, that they must consent and or not, or if they don't consent, there will be some kind of consequence or negative repercussion. Your child will be taken away, etc. That compromises the legal validity of the consent provided.
And then we turn to section 265.4, where an accused alleges that he believed that the complainant consented to the conduct. If a judge is satisfied that there is sufficient evidence and that if believed by the jury, the evidence would constitute a defense, she'll instruct the jury when reviewing all the evidence to the honesty of the accused's belief to consider the presence or absence of reasonable grounds for that belief. So that would also apply in this case, I presume, that a doctor could argue that he had a good faith belief that the complainant had consented to the conduct.
Yes, and that's true of all assault law, but what this provision does is sort of an evidentiary provision almost. It says, well, when you consider the honesty of that belief, you also have to consider whether or not there are reasonable grounds for that belief. So a bold assertion that I believed something isn't sufficient to show why you believed it.
Do I have any more time?
Another minute or so? Yes.
Okay. So I was one of the I had a lot of problems with the bill as originally drafted. I was concerned that it infringed on the rights of trans youth to have gender-affirming surgery. I was concerned that it presumptively made all sterilizations criminal, and I was concerned about a chilling effect. Just to be clear, this no longer impinges on the rights of trans people to seek gender-affirming surgery.
Yes, it comprehensively addresses the chilling effect concerns that this committee was discussing prior to summer recess, because it doesn't change the law. There is no offense of performing a sterilization procedure. That was the offense that caused, I understand, the greatest concern among members of this committee, because the doctor, in order to exculpate themselves, would have to show compliance with a number of administrative measures that are more appropriate to provincial and territorial health law than to the criminal law. So because this amendment that Senator Boyer has put forward is a for greater certainty clause, it serves to clarify the law only. It will not alter the scope of existing assault law and cannot have the effect that you're noting.
Thank you very much.
Thank you. Senator Sudar.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. I'd like to start by stressing the fact that despite I have two questions, I support the bill. I'd like to thank Senator Boyer and all other senators. I'm new on this committee, and I'd like to thank you for all the hard work that you've done thus far on an issue of great importance. This is a fundamental violation of women's rights, what we're currently discussing, and I'd like to thank my gentlemen colleagues for being here too with us. Oftentimes it's a topic that is discussed only among women. I think we're dealing with a very serious societal problem that we all need to deal with together. Thank you also to the officials from the Department of Justice for their amendment. I have two questions, two concerns in fact, about the notion of consent. At the start of my career I worked hard and at length on the provision, i.e. manipulation, maiming of the genital parts under paragraph 3. And in paragraph 3, the same section of the current bill on the issue of consent, where there are exceptions, I can't fathom the fact that one might make an exception of a procedure, of course, a person of adult age, that would cause bodily harm. Why isn't it that the criminal code includes reference to paragraph B or subparagraph 3?
Question. These are complex provisions. I want to acknowledge that at the outset. Female genital mutilation is just a label. And when you look at the for greater certainty clause in subsection 3, it says that wounds or maims includes excising, infibulating, and mutilating in whole or in part, and then the female genitalia, but it specifies female genitalia. It doesn't say FGM anywhere. Now, excising really means to cut. So it could potentially capture a situation where a doctor, with the full informed consent, legally effective consent under assault law of the patient, removes something from, let's say, the labia of a woman because it's a cancerous growth, or we have had, I understand, cases where women who've been subjected to female genital mutilation would like reparative surgery. All of that requires excising those particular parts. So if you have a provision like in sub 4 that says no consent to the excision, infibulation, or mutilation is valid except where it's a legitimate surgical procedure, you need that except where it's a legitimate medical procedure, or else doctors will not be able to help a woman who has cancerous growth or would like the damage done by FGM repaired. That's why the provision is set up this way. It's different from the provision that the Senator has put before you today, but that's because female genital mutilation is fundamentally different from a sterilization procedure. One is not a legitimate medical procedure, and the other is. So the law must recognize valid consent to what they called in Joe Bidon appropriate surgical interventions. And I think we would all agree that removing a cancerous growth to save a woman's life from her genitalia is a legitimate medical procedure to which she should be able to consent and which the law ought to recognize.
Merci,
Well, thank you very much. My second question, still on the issue of consent, but more specifically to do with the topic we're discussing. Now, in the explanations, the Canadian Association for Medical Protection requires 3 criteria for valid consent: that it be free, not under duress, and third, that it be provided by a person who is fit to consent, and I'll come back to that in a moment, and finally, that it be informed consent. Now, you understand that we're talking about sterilizing often people with cognitive disorders, and I'd like to know your thoughts about consent when it comes to those particular females with cognitive impairments.
So I would draw the committee's attention to the Re-Eve case, 1986, Supreme Court of Canada, which found that the court cannot exercise its parens patriae jurisdiction to consent on behalf of somebody who is cognitively impaired to non-therapeutic sterilizations. And that's because non-therapeutic sterilizations are not for the benefit of the patient. So that issue, I think, was comprehensively addressed there. You raised also provincial territorial health laws, and they will also they'll be different according to each jurisdiction, but the overall principles are the same, and there are capacity to consent rules in those statutes that must be followed. So that would be my comment. And my other caveat is that we're criminal lawyers, not health law specialists. So I do know something about provincial territorial health legislation, and I'm happy to refer you to examples, for example, in the Ontario's Healthcare Consent Act, if the committee would like to review them, but we're not experts on that type of legislation.
Okay, merci.
Thank you, Senatress. Are there other questions that people would like to raise of our witnesses? Hearing none, let me extend, on behalf of the committee, our thanks for you taking the time to be with us, answering our questions, and providing a framework for all of us, men and women on the committee, to understand this issue better. I think that was very helpful and, in some cases, necessary. So much appreciated. Where we are now, Senators, is that the steering committee had contemplated on a tentative basis moving to clause-by-clause consideration. I wanted to confirm your willingness to do that, in which case we would begin clause-by-clause momentarily. Agreed? Okay, thank you. So we're going to turn to clause-by-clause consideration. This could be a simple, I don't want to say unusual, but a simple exercise, because I think Senator Boyer has a one, let me call it substantial amendment to the original bill as presented. So is it agreed, colleagues, that we proceed to clause-by-clause consideration of Bill S-250, an act to amend the Criminal Code sterilization procedures? Shall the title stand postponed? Shall the preamble stand postponed? Here we go, Senator Boyer. Shall Clause 1 carry? Senator Boyer.
I have a motion. I move that Bill S-250 be amended in Clause 1, A, on page 1, by replacing lines 11 to 22 with the following: 268, 1, sub 1, for greater certainty, a sterilization procedure is an act that wounds or maims a person for the purposes of Section 268(1). Number 2, in this section, sterilization procedure means the severing, clipping, tying, or cauterizing, in whole or in part, of the fallopian tubes, ovaries, or uterus of a person, or any other procedure performed on a person that results in the permanent prevention of reproduction, regardless of whether the procedure is reversible through a subsequent surgical procedure. And B, on page 2, by deleting lines 1 to 36, and C, on page 3, by deleting lines 1 to 9.
Thank you, Senator Boyer. Would you like to say anything further about this amendment beyond what you said and what we heard from the witnesses at this point?
No, I think I've said everything. Thank you.
Thanks. Could I invite further comments and interventions by other senators on this point? Hearing none, let me move to this question. Is it your pleasure, honourable senators, to adopt the motion in amendment? I declare the amendment carried. Shall Clause 1 as amended carry? Thank you. Shall the preamble carry? Carried. Shall the title carry? Carried. Shall the bill as amended carry?